I'm Vanessa, and I'm your host for this session. Good evening, and welcome to the WebEx session on how can we accelerate e-arbitration in times of COVID-19 with American Arbitration Association. This session will be presented by my colleagues Sahil Kanuga, Payel Chatterjee, Alipak Banerjee. We also have with us Ms. Smrithi Ramesh. Please note that this session will be in listen-only mode and will last for about 60 minutes, out of which the first 30 to 40 minutes will be spent on panel discussion. The remaining time will be available for Q&A, requesting all participants to be on mute mode for this session. You can post questions on. The moderator will queue up the questions for the speakers accordingly. Should you need any assistance during this conference, please use the chat option. Do note that this conference is being recorded. I now welcome our session presenters, Mr. Sahil Kanuga, Co-Head International Dispute Resolution and Investigation Practice; Payel Chatterjee, Leader, International Dispute Resolution and Investigation Practice; Alipak Banerjee, Leader, International Dispute Resolution Investigation Practice; Smrithi Ramesh, Director, American Sahil.
The last few words of Vanessa's introduction got a little gobbled up thanks to bad mobile phone networks. So let me reintroduce Smrithi. We have Smrithi Ramesh with us. Smrithi is a director with the American Arbitration, ICDR. She sits out of Singapore and is part of the Asia bench. So that's just a quick introduction for our fourth panelist. So good evening, everyone. Thank you for joining us. I trust everybody is safe and well isolated. Today's webinar is based on how to accelerate your arbitration proceedings. Now, before we jump in, I'd like to remind you that we have some time at the end for question and answers. Please do keep your thoughts ready. We hope to have a very engaging conversation at the end of the session. Let's now take a moment and understand how we are where we are. Now, the courts in India have traditionally held long delays. Everybody knows this. This has led to the growth of alternative dispute resolution, where mediation and arbitration have emerged as preferred mechanisms for dispute resolution. Now, although very effective, mediation is not a binding method and therefore is taking its own sweet time to become mainstream. This has left arbitration as the preferred choice for most parties to a traditional commercial contract. So in that sense, most commercial contracts today, prevalent across India or in the world, would have arbitration as a preferred method of dispute resolution, and that's binding on the parties. Now, over time, India evolved as the center of ad hoc arbitration. In the recent years, institutional arbitration has grown tremendously, and we now have the benefit of fantastic global institutions, such as the AAA, administering arbitrations for commercial disputes. They do this in India, they do this globally, so fantastic. Within arbitration, there was already a very strong move to reduce physical arbitration hearings and embrace technologies such as video conferencing and teleconferencing. But this shift was slow because people liked the traditional method of holding physical meetings or hearings. They were the order of the day. Now then, the planet got hit with COVID. This is making us reinvent the wheel. Now, with this in mind, let's jump into the topic at hand. What is e-arbitration? It's nothing new. It's been there for a long, long time. People have been using video audio conferencing for their hearings, no problem at all. While earlier, the driver for using these technologies was an increase in overall efficiency as well as a reduction in cost, the major driver now will be COVID. Everybody wants their arbitration or the dispute resolution to move forward. Nobody wants to be stuck sitting at home doing that. There is also an additional option available. While it was also present earlier, it was rarely used. This may well change given the current circumstances. It's a document-only arbitration. Something very rarely used, but it's there. The law provides for it. Now, to delve into this, Payel, can you explain explain the nuances of a document-only arbitration?
Thank you, Sahil. Good evening, everyone, and thank you for joining our session today. Suddenly, with the rise of COVID, people have started looking at other alternative resolution modes. But the fact is, it can be summarized in one statement. It's looking at old wine in a new bottle. The resolution mechanisms, all the other alternatives were always available. And as Sahil rightly mentioned, one of the modes was document-only arbitration. But it's not applicable in all scenarios. Where is it applicable? What is the concept actually? Certain high value complex disputes require parties to have full-fledged examination of witnesses. You may require experts to tender their evidence, and you require full-fledged oral hearings. But this is just one category. In addition to that, there could be several mid-level disputes depending on the quantum involved. It could be certain things in relation to maybe a low value dispute, but you require certain specific reliefs which are in that particular matter. In such cases, the nature of a document-centric arbitration, parties can opt for a document-only arbitration. Let's look at the three scenarios where we can have a document-only arbitration. It will be great if it's already incorporated at the outset in your arbitration agreement itself between the parties. The second aspect could be you have opted for an arbitral institution in your agreement, which has a mechanism and provides for document-only arbitration. It need not be just restricted to the expedited form of arbitration, but even for regular arbitration. And the third aspect is at the time of appointment of your tribunal, if both parties consent to and can go ahead with a document-only arbitration. This is more or less on the concept or scenarios on where you can go ahead with documents-only arbitration. But was it there as part of the law? Had the arbitral institutions across the globe looked at this aspect is critical. Let me start firstly with the Indian Arbitration and Conciliation Act. It's nothing new. You may not have a specific section which talks about or which is titled a documents only arbitration. But let's go back and look at part 1 of the Act, which provides clearly that in certain cases, there is no requirement of having an oral hearing. It could be done purely on the basis of a documents only arbitration. Only if parties request or the tribunal feels it's necessary, then comes the question of conducting oral hearing. Now, this is something which has been there in our Act since 1996. Then comes in the amendments, which were introduced in 2015, which brought in place Section 29B, which dealt with the concept of a fast-track arbitration. Let me be clear, one should not use that it's only in fast-track arbitration that you can make use of a document-only arbitration. That's not the concept. It was always there, even for traditional arbitration. The fast-track arbitration ensures that prior to the appointment of a tribunal, the parties can opt for and choose to go ahead and have a document-only arbitration. Now, this is the Indian scenario. Moving a little forward, we have various institutions, be it the American Arbitration Association, be it LCIA, ICC, CAC, all over. Everyone has come up with expedited arbitration as well as document-only arbitration. Since today we have the privilege of having Smrithi with us, I would request Smrithi to say a few words how American Arbitration Association looks at the concepts of a document-only arbitration.
Thank you, Payel, and good evening to everyone who's joined us today. I think Payel kind of summed it up very appropriately, saying the best stage to agree on a document-only arbitration is at the agreement stage and not when the dispute actually arises. Now, just to give you a little bit of information about how the AAA does vis-a-vis how it's panned out, do we actually have successful documents-only arbitration? Now, we have built into our rules a clause that says if there's a dispute under $250,000 value, then it automatically takes the expedited track unless parties opt out of it. Now, a further subsect of that is a presumption that if the dispute's under $100,000, it's automatically presumed to be documents only. Now, what are the benefits of doing that is, I think the first benefit is just a logistical advantage, but is huge, is the cost that is the cost factor that is passed on to parties. Now, what also happens in a documents only arbitration is you get to cap the time, because oftentimes an arbitration gets extended only because of the time that it takes. For example, under our rules, once there's a procedural order, if there is a documents only arbitration, then the entire thing has to be completed in 60 days, which is to say that all the submission, etc., is to be completed in 60 days. Now, there's also an option, because autonomy is key and flexibility is important. It's important to have the option of being able to include an oral hearing should the need arises, because nobody knows how the proceedings are going to evolve. Now, coming to the next point, this is something that we've seen in action quite successfully. One of the incentives that we did when we drafted the rules was that as far as our administration fee goes, a huge chunk of the fee only kicks in if you actually have oral hearing. So you end up going to documents only. The only fee you pay the ICDR is the filing fee. And while it's not the most important thing in the scope of arbitration, when you start looking at logistics and issues like that, it becomes very important. Now, I do want to add one rider, and I think Payel already brought this up. This is not something that's applicable per se to all disputes. Neither does documents only have to be restricted to a particular monetary value. There could be an exceptionally high value claim arbitration that relies solely on one issue, or an issue that's easily possible done documents only. So in those cases, I think documents only become very well suited, irrespective of the rules that you adopt.
Thank you, Smrithi. Very, very interesting. You've said a bunch of things in there, and I have a couple of questions myself, but I'm going to save it for the rest of the discussion, which we're going to have at the end. I know for a fact that Payel has actually done a documents-only arbitration, so I would like her to discuss with us a little bit about how she has seen it play out in the Indian context. Does it work? Does it not work? Is it something worth considering?
Thanks, Sahil. So interestingly, we worked on a matter almost 7 years back. And I'm going to start with how the clause in the agreement actually read, because that's where the crux was. It did provide for an institution which would appoint the tribunal, and it provided for a separate institution whose rules were to be followed for administering the arbitration itself. The second aspect of the clause was it gave a time-bound period within which the award had to be delivered, which was, if I recollect correctly, it was 120 days. We started with our invoking of the arbitration notice. We got from the other side. We moved forward, put the institution in place, and started with the process on the appointment of the tribunal. Party stopped reacting or responding to the proceedings itself. We, on behalf of our client, the tribunal got appointed. Looking at it was completely an issue where there was an acknowledgement of a debt purely based on the
Payel, sorry to interrupt. The last 10 seconds were a little garbled because of a bad network. Can I ask you to repeat, please?
I think I had left at the fact that we were going ahead with invoking the arbitration. The notice was issued. The other side responded to that as well. Then we started with the process of the initiation of the appointment of the tribunal. That's the phase when the other party disappeared from the scene. However, we went ahead and the tribunal got appointed. Now, how did the first hearing happen? It was a pure procedural hearing which happened on teleconference. Schedule was laid down till the stage of actually submission of the pleadings. Then we realized it was going to go ahead. The other party was not at all responding to the proceedings. aspects which we considered while doing this document-only arbitration. Ensure that at every stage, the other party is aware of the proceedings, is kept in the loop, so that later issues like procedural unfairness, principles of violation of principles of natural justice do not crop up. They do not, they were under some incapacity or they were not able to represent their case itself. Ensure you serve them at all stages with all pleadings, affidavits in place. So we did all of that, yet nothing happened. We even decided to keep the proceedings maybe in abeyance for a period so that maybe we get some kind of a response. Because mind you, when you're there, the costs are also a factor for the client. And when the other party is missing in action, entire burden of the cost falls on one party. To go ahead. The issue in that case, the tribunal started reading up the papers and the pleadings, and they realized it's an issue which is purely legal, based on contractual interpretation, and there are already enough documents to show what the parties are trying to establish. Based on the second procedural call, a decision was taken that we will go ahead and have a document-only arbitration and not actually require any kind of evidence to be led, cross-examination, or oral hearing. One of the interesting things we saw after the completion of pleadings as well as our witness statements, the tribunal have reviewed the documents in so much in depth, we got a complete questionnaire of 20 to 30 questions saying this paragraph, this pleading, please explain us this concept, which shows the thoroughness of the tribunal and also shows that how an arbitration can work so effectively. You really don't need parties to come before each other. You don't need 20 people gathering in one place. Everybody in different jurisdictions get the arbitration and the dispute resolution mechanism is working. The last bit which I would add on the documents only aspect is not only did we get an award, we have managed to successfully enforce the award as well in the Delhi High Court. So the best part is when the enforcement proceeding started, that's when the opposite party came into action. And as I mentioned earlier, one of the grounds for challenging or objecting to the enforcement itself was procedural unfairness, principles of natural justice, they not being served with the papers, as well as on the grounds of public policy. We were successfully able to go past against all of these challenges and objections, purely because the reason in which the arbitration was conducted and ensuring the fact that procedural unfairness does not take place. And I think it's an excellent example which shows that arbitration at the end of the day, what is the hallmark? Procedural. Thank you, Sahil.
Thank you, Payel. I think what we heard and my takeaway from that is you can move to a documents-only arbitration and it can be very, very effective. Now, I think most of us are conscious and most clients will also agree that documents-only arbitration doesn't work for everything. There are cases where you may need a physical hearing. Now, Alipak, assuming there is a situation where a documents-only arbitration doesn't work, what are the other options available to a party in today's scenario?
Thank you for that, Sahil. I think first we need to look at the kinds of hearing which takes place in an arbitration. The first set of hearing is preliminary issues or procedural hearing. I think in today's context, even before COVID, I think 85 to 90% of the hearings, they were done by audio conference or video conference. So to that extent, there will be largely no impact. These are hearings where you basically set out the timelines, or if there is a requirement of a very urgent interim protection, so on and so forth, where you don't have time to constitute the tribunal. Because in a large case, maybe the three arbitrators, they will have their own different schedule. It takes 3 to 4 months for scheduling of physical hearing. So these hearings are very common and to a large extent, they will not be impacted. Now the second set of hearings are evidentiary hearings. That is the tricky part. Now, yes, even in the past, parties have conducted cross-examination using video conference. It works, in 50 to 60% of the cases. And with the use of technology, you could also show certain documents to the witness and ask him or her to respond. But again, in a given case, you also judge the body language of the witness, and then that's how the art of cross-examination flows. So when a witness is there on a video conference, you may not get that flavor out of it. So at the end of the day, the transcription which you get, it may appear that the responses to a large extent are well thought of, whereas in a physical hearing, you could get an impromptu response. So that is the realistic or a practical drawback which one can face in a given circumstances. Now the third bit is the final hearing. Now in last 5 to 10 years, in all
Alipak, sorry, I think we lost you for a minute.
You're on mute, I think.
Yeah.
Yeah. Yes.
Hello.
I'm sorry, I think we lost you. Can you just repeat the last 15 seconds, please?
I'm so sorry. So the last chunk is the final hearing. And in last 5 to 10 years, in most of the big ticket arbitrations, there is an increased reliance on the submission, which would mean before the hearing, you would file a detailed opening submission. And then after the final hearing, you will file a detailed closing submission. And in many cases, there is also an opportunity to file a further responsive closing submission. Now, with these kind of 3 submissions, the reliance on final hearings have significantly narrowed. Only on critical issues of facts and laws, on question of law, hearings take place. Now, to my mind, final hearings can be conducted on video conference, and there should not be any impediment because that would be largely a question of law and fact. Now coming to this, these are the avenues available for an existing arbitration. Now, if you were to start or you have initiated a new arbitration, then there are a couple of things which one can consider. Often there is a dispute on interpretation of the contract, or there are issues which can be bifurcated during the arbitral process. Like for example, there could be an issue on jurisdiction of the tribunal, whether certain issues are arbitrable per se. Now, in the given time, the parties could possibly file an application seeking a bifurcation of the hearing and convene the first set of hearing, that is the hearing on jurisdiction, which would be largely a question of law. And that can take place on video conference and park the issue on facts, evidentiary hearing, to a stage when maybe the situation improves. Now, these are practical situations which one can consider given the facts and circumstances. Now, there are other 1 or 2 nuances which I would just like to touch upon. Document production. Now, in large arbitration, a lot of time is spent on discovery and document production, wherein a party they fill up the refund schedule and request production of certain documents. Now, the practical difficulty is if certain documents are in your office and there is a lockdown in the country, it may not be possible for you to produce these documents at that relevant time before the arbitral tribunal. Now, in such instances, the tribunal usually takes adverse inference. That is, that you have the possession of these documents, but you have purposely not produced them So because you fear that there may be certain submissions, or there may be certain points in those documents which would adversely impact your case. Now, it would be very interesting to see how tribunals in the present context, in the present circumstances which we have, how they look at these kind of situations. And finally, I would like to touch upon interim relief. Now, we have a situation which may not improve in next couple of weeks or couple of months. Now, interim protection, therefore, will become very important. Now, if you have a case which is running for couple of months and hearings are getting cancelled, but you could file an application and request for a short interim hearing just to preserve or protect the assets or some kind of an injunction order. So these are the tactics which a litigant may adopt to sail through their arbitral process in the present time.
Thank you, Alipak. Now, I think the one person on this panel who would have seen the situation explode around her and is seeing the solutions also is Smrithi. Smrithi, what's the American Arbitration Association's experience on this? You would have seen this in Asia, in Europe, in the US, all over the world. Talk to us.
So just before talking to you about the AAA experience, I just had a couple of points to add to what Alipak said, only because I think it makes a lot of sense to think about it, and you will see a fresh wave of rules being amended soon. But the one way that we actually got around it is our rules actually has a provision that says parties should make documents available in the form that is most convenient and economical for it, unless the tribunal otherwise orders so. And this is particularly done with an electronic form, keeping that in mind, or for emergencies that come up. And I do want to bring about one other point, and I will not delve on it, but this is something that I feel like is something that's going to take force in India. Is recently we started something that's called the streamlined arbitral tribunal complex, which is to say for really large and complex disputes, we split the process into one arbitrator going through the motion of discovery, etc., and having the 3-member bench only sit for the final hearing and award. What this does is, especially in large and complex matters, is it brings about such a tremendous cost benefit, because we realize it doesn't just cost 3x the times, it costs somewhere 5 times that of a sole arbitrator. So the point being, even for existing arbitrations, I think there's a lot of mitigating steps that can be taken, at least to see through the crisis. Which actually gives me a nice segue to talk about, Sahil, what you mentioned. Now, to me, in my mind, especially at the time of COVID, I feel like the biggest benefit of institutional arbitration, which has been something that none of us mentioned, including myself, is the existence of a business continuity process. Is something that kicks in at times to serve the stakeholders. And what we've been doing is pre-crisis is we have our own proprietary case management portal for not just us, but for stakeholders and parties and arbitrators. So what this helps us do is, except for the physical hearings, which were obviously cancelled, we were able to go ahead with all other aspects of case management in the process, including electronic hearing, facilities, IT, finance, etc., with no disruption. Now, one of the things that's important for how we do this is the problem is not just giving people or asking people to do electronic arbitration, but also giving them a platform where they can facilitate the exchange of documents. And especially when you read on the newspaper every day that there's cyber fraud, there's phishing, etc., it actually falls on the institution to be able to give that platform where they can safely and securely exchange documents and also store documents. So basically, what we do is we also have backup servers and also cyber recovery disaster plans, which happens a lot because we're talking about COVID now, but tomorrow if we're talking about a natural calamity, and then you're going to lose all your data. So institutions' role is actually to step in and provide for disaster recovery, irrespective of what it is. So that's something we do. And I want to briefly touch upon, before I talk about the process itself, the other most important thing is the ability to handle, because when something like this happens, you need to be able to scale up. And your stakeholder needs to have that sense of trust in you that you're not designing this super expensive system and passing the costs on as administrative costs. So, there's no shortcut for that. The way the AAA gets by that is because our domestic cases are about 500,000 a year. Our international cases is 1,000, and our portal's built to withstand that. So we just take strength in numbers. So we're not passing the cost on really. Now, what are the process enhancements we have? Alipak mentioned everybody's already been doing some form of electronic arbitration, either by email or filing. What we now did is we came up with a fast filing because we anticipate that a lot of banks are delaying transfers, which is happening in a lot of countries. So we now actually have created a credit card portal, at least for the filing fee. So when you're dealing with something like a limitation, you're able to commence the arbitration and you're not inconvenienced because of that. We've created digital technology for breakout, yes, but we actually successfully 2 weeks ago, we held 2 hearings, evidentiary hearings, entirely online, including curating breakout rooms and all of that. The most important, I think, and is very underrated, is the portal for document transmission, because you don't want people, I'm not mentioning, but you'll oftentimes find a zip file, click this to open it. You don't want that because that hits you on multiple levels. Later, it could be a procedural discrepancy like Payel suggests, or someone could claim the, so you have to have that portal for document management. And yeah, sorry, I think I do have a minute or two. The other most important thing is how you handle it, because a lot of these issues that we talk about, including is my electronic document valid? I haven't served it with registered post acknowledgement due. Is my entire process at this point invalid? Is to be able to have that procedural order in the beginning that's taken by the institution that acknowledges and records that all this is acceptable. For us, what happens is because we put it into the rule, we're able to subvert all these questions as long as the arbitrator says this is the most convenient and economical way to transmit the document, so we're going to go for it. Now, the last point might seem funny, but it's actually relevant, is to have a tribunal that is technologically savvy to follow through with this, parties that are savvy to understand. It's not rocket science, but you still need to go through, because we've actually had cases where an arbitrator logs in from Starbucks, somebody hacks the case, and the entire thing comes crashing down, as funny as it is. But so it's important to go through. So we do that. We actually offer free training, cyber security, we encrypt it, and we have a cyber response backup, because these incidents are more common than you think it should be. So I think this is the sum total of how you use technology. I just want to sum it up saying this enhancement to technology should not be a standalone thing that we look at now. It has to be something that we slowly adopt. Perhaps the only silver lining here is that people who are hesitant to try technology are going to be forced to do it. So maybe we're speeding up the process a little bit, but it's definitely coming, and we have to get on board with it.
Thank you for that. I couldn't agree with you more. You know, as I was hearing you, I could relate with everything that you've said, because, you know, we've had military-grade security for the longest time. We have a document management system. We restrict access to on a completely limited access basis. Only a particular team that is working on a matter has access to the documents. We've had these practices ingrained in our system for the longest time. In fact, we've even seen recently that certain online platforms which are using video conference facilities, I'm not taking any names, are actually quite, they're not secure, and they've been hacked very, very often. What we have been assured is what we use is military grade, and it's completely unhackable. So when this happened, for us to move our practice home and work seamlessly from home, it was literally like sitting in your office. You just having a cup of coffee at home, but you are working from your desk. So the shift was seamless. You're right. It's important to embrace it on a day-to-day basis rather than at one time.
Yeah.
Now, just wanted to share my little experience with you. Moving on, conducting an arbitration on electronic platforms, audio conferencing, video conferencing, has certain practical issues. I'd like to ask Payel to share some practical issues that she has seen with us.
Thank you, Sahil. What I'm now has already been discussed by some ways or the other. But let's go back to the basics actually. Arbitration is what? At the end of the day, it's very innovative and it is inherently flexible. And the thumb rule for arbitration is party autonomy. I think these are the cornerstones based on which an arbitration process actually moves ahead. Now let's understand if we go ahead with an e-arbitration. Technology not to epidemic situation, but going forward. Having said that, what could be the possible scenarios? One of the situations which Alipak mentioned was in relation to examination. Through video link, and it has been done by various arbitral institutions as. But the question is, you have a witness in one place, you have the counsel at the second place, the opposing counsel at the third place, and if it's not a sole arbitrator but 3 arbitrators, 6 different locations is where you are based. If that's the scenario, is it actually practical or is it feasible? Second, what do you do if you're stuck in an existing arbitration with an arbitral institution which supposedly does not provide for this facility? How do you manage yourselves or move around to manage the schedule or the timetable in such cases? What do you resort to? Do you resort to adjournments in that particular case? I am an internal optimist. I have pointed out what could be the issues, but let's try and look at and see at the brighter side of the curve. I think the arbitral community is well ahead of it already. They could come. I mean, we have already thought of these situations and already have answers to this in place. Let's start with the first thing, flexibility. Okay, we have travel restrictions. So that's precisely the reason on video conferencing. It is going to free up a lot of schedule and timetable for a lot of people under the who are participating in the arbitration. You do not have that many process. You do not have to organize for a travel. Video conferencing works perfectly well. The second aspect, the video protocols are already existing. We have several guidelines, we have several institutional rules which have been laid down as to how do you go about conducting a cross-examination as well as oral hearings. So I think the stage is such where IT is booming. It's the age of digital economy. When we are talking about all of this, how can arbitration be far behind? It has to support that. I think it's the perfect situation where it's the marriage of technology with arbitration. But as Smrithi rightly pointed, there are going to be cybersecurity issues. Rightly so. Data privacy, cybersecurity, these are issues which are actually frightening the parties as to how do we deal with our data. So for that itself, along with various institutional rules itself, 2 years back, the sole protocol was released, which actually gave down some certain technical specifications and practical guidance as to how do you go about planning, logistics, and training when it comes to video conference. It cannot be that you try it only when the hearings are going on. It has to be tried and tested. I'm sure there are going to be frustrations down the way. It's not going to be an easy walkthrough process, but it's something with experience we will learn. I think the requirement is a shift from our mental perspective as to how we approach arbitration and how parties look at it. There is no requirement to have a physical appearance and for a face-to-face interaction anymore. Now, this is when it comes to the arbitration. Maybe we are done with the arbitration from an electronic mode. Parties might be concerned, how am I going to deal with enforcement? What is the award itself. Does it pass the test? What are the kinds of objections which will be raised at the stage of enforcement? In addition to the procedural unfairness aspect, which we have already dealt, the next issue is, let's take the example of Indian Arbitration Act. It has a specific section related to the form and content of the award, which says a signed copy needs to be delivered to the party. Let's forget e-arbitrations. Today, with most institutions, we see the tribunal first sending you the award itself. All exchange of pleadings are also happening electronically. So let's come to the stage of award. Why do I need a hard copy? The requirement was maybe after printing it, the arbitral tribunal signs it and sends their copy. But there are digital signatures, and that's precisely the reason the marriage of IT and arbitration needs to take place. Digital signatures are upheld as valid already under the IT Act in India. So if an arbitral tribunal digitally signs the award, I do not see any difference when it comes to e-arbitration or a traditional method of arbitration. And the last point which I wanted to deal with, which Alipak had touched upon, was in relation to document production. Now, there are several guidelines which have been laid down, which include that document search, review and production mechanism, as well as the process which needs to be followed. What we need today is actually, we have always known of having a tribunal secretary. Maybe it's time we introduce a technically person who is educated assisting the tribunal as well, which ensures that you have a platform where you can upload documents with the kind of systems which you are using. For example, our webinar today itself, the Cisco WebEx allows you to even share documents. So what's the problem in doing a hearing or a cross-examination when everything can be shared if it's uploaded? The platform needs to be a good one, a recognized one, which ensures that data protection measures have been taken in place. And we already have initiatives taken by the arbitral community where they have come up with a joint task force which has already introduced a draft guideline with respect to data protection itself in arbitration. So I think it's more of a mental shift which we need to do, and all the remedies or the solutions are already in place. It's just about time we start moving in that direction. Thank you, Sahil.
Sure. Smrithi, any thoughts on this, or can I move on to the next question?
I think the only possible con in this entire thing, and it's a difficulty that we've been facing, is as long as both parties show up, there's always a way out. But there's oftentimes, especially when you're doing an international arbitration, but one party never shows up, and you're stuck with an ex parte arbitration, in which case implementing this both from an institutional perspective and this becomes difficult. Now, I don't know what the solution is for existing arbitrations, but I do know this is something that parties can think of while drafting, which is where things like expedited procedures come into play. Because if nothing, then at least the automatic rule kicks in. But yeah, like Payel said, these sort of practical difficulties are going to arise, but they've also happened for real hearings. So we'll just find a way out of it, and a much cheaper way out of it at that. Yeah.
I think so.
Before you proceed, I just wanted to add a quick point which I thought would be relevant for the audience. We have been facing several issues across other platforms. I think it's highly relevant that people understand which platform they are adopting to and whether it's secure or not. Of late, we have seen in several discussions and other webinars where other platforms have been used, security concerns have been raised. It might be that's where the concept of a good platform, and I think the best example is the Cisco web itself, which needs to be implemented across organizations and institutions for people to be in sync, which is the platform they need to go ahead with.
My point exactly. Perfect. Now, moving on a little bit and departing from the topic a little bit, Alipak, there have been recent updates in the arbitration landscape in India. Things have moved a little bit further. Would you like to highlight some of them?
Yeah, sure. I think two important updates which I thought I'll share is, and they are, The first one is seat versus place versus venue of arbitration and the supervisory jurisdiction which the court will have. I think this has been a bone of contention in a lot of existing cases. Personally, at least I have done 3 or 4 big arbitrations where parties disputed the seat of arbitration, and we fought for a good 7 to 8 months, only adjudicating that issue. Now the Supreme Court has clarified some bit of it. So first I'll deal with India-seated arbitration, and then I'll come back, then I'll follow it up with what happens in foreign-seated arbitration and how courts in India would have jurisdiction for interim relief, so on and so forth. Now, just to start from basics, seat is the center of gravity in an arbitration. That basically denotes designation of a court which would have supervisory jurisdiction, which basically means that you could take recourse to that court for seeking interim protection, for challenging the mandate of the arbitrator, for challenging the award, so on and so forth. Venue, on the other hand, is a convenient venue where you conduct the hearing. Now, Indian Arbitration Act, it does not mention the word seat. It merely uses the word place of arbitration. Now, let me put an example, and then I'll come to the case laws. Just imagine a situation where in an arbitration clause, the seat of arbitration is designated as New Delhi. And in the same clause, it states that for the purposes of recourse to court, courts in Mumbai would have exclusive jurisdiction to deal with issues. This is a classic case where there is a confusion as to whether you should go to the courts in Delhi or whether you should approach the courts in Mumbai. Now, we will answer this question in a minute. Now, let's look at what Supreme Court has said. Supreme Court in BGS Soma versus NHPC, Justice Nariman's judgment in December, he has categorically held on this issue. In that case, the clause merely stated that the arbitral proceedings shall be held at New Delhi / Faridabad. It did not mention venue, it did not mention seat, nothing. Arbitral proceedings were conducted in New Delhi. Arbitral award was passed in New Delhi. However, subsequently, the respondent, they challenged the arbitral award before courts in Faridabad. Now, that was appealed before the High Court, and finally the Supreme Court had to decide this issue. Supreme Court held that when parties have, so it can be clubbed under, it can be divided under 3 different buckets. So when the parties have chosen a seat of arbitration, or if the arbitral tribunal has determined a seat, such a determination automatically confers jurisdiction on the court at such seat of arbitration for the purposes of interim order and challenges to an order. It specifically opts out enforcement. Enforcement is different. The law on that is wherever assets are, you could file enforcement in that territorial jurisdiction. Now, what happens if seat is not mentioned? Now, when seat is not designated by the arbitral agreement, or if a convenient and only a convenient venue has been designated, there may be several courts where part cause of action have arisen, and you could elect one of the courts, and the courts that you approach first will have the jurisdiction. This is a case where you don't have seat, but you have venue. Now, if you don't have seat and neither do you have venue, then it would depend on your cause of action, or there are tests laid down by English cases where the contract has closest connection, so on and so forth. And that's the third umbrella is a very complicated situation. Now, so what is the practical takeaway from this case? If the seat of arbitration is mentioned, then you have to only approach the courts having the territorial jurisdiction of that place, like in the given example which I just mentioned. So the courts in New Delhi will have jurisdiction, as not Mumbai. So to that extent, as soon as you designate a seat of arbitration, even if you have exclusive jurisdiction in that clause, to that extent, that exclusive jurisdiction clause will have no meaning after this judgment. Now, if the seat of arbitration is not mentioned and only venue is mentioned, so unless there is a contrary indication, venue can be constituted as seat. Now, Supreme Court in their judgment, they have given 2 examples. Like, for example, if it says that the venue for arbitral proceedings shall take place in New Delhi, that is a sufficient indication to say that the venue was meant to be seat. On the contrary, if the language says that the tribunal are to meet or have witnesses, experts, or the parties in New Delhi and Mumbai, that typically denotes that that meant that the venue of the arbitration will be at that particular place and not seat. What happens now? This applies in India-seated arbitration. Now, what happens in foreign-seated arbitration? Like, for example, a AAA arbitration seated in Singapore or New York. In that circumstances, while the Singapore or the New York court will have the supervisory jurisdiction, you could always come to Indian court for recourse to relief such as interim protection. In that situation, if you mention exclusive jurisdiction, then that will have water. You could then, within India, go to the designated court and apply for your interim protection. Now, this was on seat versus venue versus place. The other point which I would want to very quickly touch upon is on limitation for filing enforcement petition in a foreign award. Now, there was a lot of confusion. The Madras High Court had a different view. The Bombay High Court had a different view. The Delhi High Court, in a recent case of Crane Energy versus Government of India, they have settled the law, and they have held that for a foreign award, you have 12 years to seek enforcement, to file an enforcement petition before the Indian court, and not 3 years. And the rationale is that foreign award, as soon as you cover the technicalities, like you produce the foreign award in original, you produce the original copy of the arbitration agreement, it takes the nature of a decree. And for decree, the limitation is 12 years as opposed to 3 for a normal cause of action. So they have extended the timeline to that extent up to 12 years. So this is an important update for a lot of clients who have foreign awards, awards where the arbitration was seated outside India. So for them, there's a relaxation. They can file up to 12 years from the date of the award. Thank you.
Thank you, Alipak. Appreciate the quick update for you. With this, we will now move on to the question answer part of the session. We already have a question from one of the attendees. His question is, supposing if a party proposes e-arbitration in an institutional arbitration proceeding, which is obviously ongoing, but due to the current COVID outbreak, the other party objects to it. Now, let's look at the situation. There's an ongoing arbitration. Parties were possibly scheduled to have a hearing at some point in time. COVID pops up. Parties can't travel. Arbitrators can't travel. One of the parties says, let's do it on video conference. The other party, for whatever reason, maybe he's a renegade party, maybe he wants to delay the proceeding, maybe he says, this is my lucky day, I don't have to go. I'm going to kick the ball down another few months. He objects to this. What happens in that kind of a situation? Now, let's first toss the ball to Smrithi on this, and then we can possibly have Payel or Alipak chip in.
So, given that it's an ongoing institutional arbitration, the first thing to do would be to go back to the rules and see what options the rules actually have in terms of deciding this. But generally, I can say this, most institutional rules, especially if the tribunal has been appointed, will give the tribunal that sort of power and autonomy to have a say in this, to be able to decide or direct, for example, the parties to come online or submit to an online arbitration proceedings. So that would be the best recourse, is to first go back to the rules and then head to the tribunal. This can be done in many ways. Now, there have been instances where you do not have proactive tribunal. My suggestion in those cases would be, when you're making a request or a motion, to always put it in writing, because once you have that on record, it possibly comes in handy, and the tribunal will have to actually give you a reasoned answer as to why it's saying no, if it's choosing to say no. Same goes for the other party. When you put it in writing, the other side has to come back and possibly look or come up with a feasible reason for saying no to that. So, yeah.
I think just to add to what you were saying, a little bit of experience that we've also had. It also depends on which stage of the proceedings you are at. If you're at a preliminary stage or if it's a general hearing, then the tribunal may very well be inclined to accept that kind of a proposal to move to video conferencing. If you're at a stage which is the sensitive stage, for example, cross-examination, where the party says that we would like the witness to remain present in front of us, we would like to see the body language, and a lot of things actually turn on these things in an arbitration or in this part of an arbitration. In that situation, the tribunal may choose to not accept it and say that let's give it some time and see how the situation unfolds. Again, you don't know how long this is going to last. It could be a few weeks, it could be a few months. So a couple of weeks isn't going to hurt anybody. So stage of the proceedings is also something to keep in mind. Alipak, Payel, any additional thoughts on this?
Here's just one thought over here. I think I'm going to play the devil's advocate and say, how do you go ahead and move past party autonomy? I mean, if I haven't agreed for an institution or which allows me to go ahead with video conferencing, or it does not provide so in my agreement itself, we don't know whether the difficulty is genuine or not. Let's forget that aspect. But if I put it in writing that this is the situation, this is actually on ground happening, how do you move past that? It's a tricky question for the tribunal as well. Are you going to put people's lives at risk? Or if that's a physical hearing, if it's a video conferencing, the party says, I do not have the technology, I am not equipped to deal with it, because maybe the documents which I need to use in the arbitration are sitting in my office. So even if I'm doing a video conferencing, how do I get those documents and how do I prepare for this particular hearing? Just being the devil out here to see how it works from the other side as well.
So one quick comment on that. And so, of course, I mean, you can't force a party who does not want to participate in e-arbitration, and if that has not been agreed previously. But what could happen is, if the tribunal comes to the view that a particular party is purposely delaying the arbitration, possibly they can take an adverse view, or, I mean, they can't take an adverse view theoretically, but at the end of the day, arbitration, I mean, the three arbitral members, they are human beings, right? I mean, you decide one way or the other, right? So in their final consideration, they will, of course, keep that into their mind, that here is a party who, in spite of repeated requests and given the circumstances, they objected to a hearing in a particular manner.
Sure.
Certain considerations may be given to that.
I think that's a good point. I think the next question we have is, in e-arbitration, do seat and venue play any particular role? Smrithi?
Short answer, seat, definitely yes. Whatever arbitration it is, documents only, electronic, seats always important. Venue may not be all that much, but I will tell you hands-on what we do from a practical perspective is just to avoid any sort of procedural issues that rise up later. We actually have certain regulations, for example, in video conference as well. We actually tell parties they can't put up fancy backgrounds that video conferencing facilities have. Your place of actually attending the video conference is recorded. And at the end of the conference, the tribunal passes a direction saying the venue of arbitration is electronic, but is considered to be, for example, whatever place was picked. This happens it has no bearing on the arbitration, but it happens from a practical perspective because I think tribunals and parties want to err on the side of caution. And that's at this point just best practice.
So, Sahil, if I may add one or 2 points on that, I think fundamentally the arbitration survives on its seat. I mean, seat is so important that if seat is not there, how do you enforce the arbitral award to a reciprocating territory? So, e-arbitration, I mean, our discussion today is on the mode that you conduct arbitration. Seat goes to the fundamentals of arbitration. So, just to give an example, Like the fact that you have a seat in Singapore, that arbitral award is enforced in India because India and Singapore, they have a reciprocal arrangement under the New York Convention, which is why that award gets enforced. The seat, of course, is of paramount importance. And venue, like you rightly pointed out, Smrithi, that venue is flexible. I mean, it depends on the convenience of the parties and the arbitrator. That can always be adjusted depending on the circumstances.
So thank you for this. I think a last question. It's from Deepu, and it's addressed to Smrithi. Working in an arbitration-friendly nation like Singapore, do you think the courts in India could learn from any specific judgment passed by the court in Singapore with respect to arbitration, with respect to the subject matter?
So,
one second. Before you jump in over here, I'd just like to say that the courts, over the last couple of weeks, we've seen them to be very, very proactive. I mean, Bombay High Court, Delhi High Court, Supreme Court of India, they've all gone online. They're having video conference hearings in urgent situations. To demonstrate urgency, we'll get your hearing. So I don't like the thing that Indian courts are behind. The Indian courts are certainly up to any challenge that you're throwing at them.
Yeah. Sahil, I couldn't agree more with you. I think what's important is to understand at least the time zone in terms of the evolution of the ecosystem. Singapore is actually a few years ahead because it started a few years earlier. And the most important thing is to remember, more than a specific judgment, it's basically the proactive role and the minimal interventionist attitude that a court takes. And like Sahil pointed out, I think a lot of Indian decisions recently are also reflecting that. And it's also sort of comparing apples and what I do also have to answer one other thing is that you will actually find a lot of Indian decisions being quoted in the Singapore cases and the other way around too. So to sum it up, just it's sort of like comparing apples and oranges at this point because how these systems work is entirely different. But it's a very, very positive development in India as well. And this is entirely my personal opinion. This might not be the popular opinion. I think what you've seen happening in Singapore recently is everything is so pro-arbitration friendly that you barely have 1-2 decisions a year to report because everything else has already been decided, and there are very few issues that happen. And I think there's very positive signs. Awards have been enforced in India very frequently. There are very few cases where courts have stepped in to refuse enforcement of a foreign award. And perhaps Alipak, you might, or Sahil, you'd like to step in and sum it up.
So I think with that, we will have to draw the session to a close. I know we're getting a ton of questions, and my apologies, we are running very, very late. If you do have more questions, please feel free to reach out to any of us. We're all on LinkedIn. We're all our emails are up there. We'd be happy to engage with you separately, and we'll respond to your questions. Thank you very much. Vanessa?
Thank you to all our speakers for a very insightful and educative discussion this evening. Stay tuned for interesting sessions every day.